Defective products are to blame for many different types of injuries each year, but it can be tough to get major manufacturers to accept responsibility. I'm Miranda Connie. You're watching WPTV's Ask the Attorney web chat. Joining me today for the first time is Lance Ivy. He is a partner at the personal injury law firm of Lytle, Ryder, Smith, Ivy, and Fronrath. Lance, thanks so much for joining us here today.
Thank you for having me.
This week we're talking about product liability law. Can you explain what that is exactly?
That's legal responsibility of designers, manufacturers, and sellers of defective and unreasonably dangerous products that hurt consumers.
Now, I know that your firm handles these cases all the time. Can you give us some examples of some of the most common cases that you see?
Commonly, we see cases where seatbelt failures occur during the accident. During a rollover, the seatbelt will come unlatched, the person gets partially or fully ejected, the airbags don't deploy when they should deploy, and a person's caused injury, or the roof collapses in a situation where it really shouldn't collapse.
Now, you mentioned seatbelts. I know your firm specifically handled some of the cases back in with the Chevys, right? Back in the late 1990s?
Yes, we had an accident that happened actually in 2003 involving a 1997 Chevrolet Trailblazer. Right. And as a result of our claim, there was a recall of over 300,000 1997 Chevy Trailblazers. And
I know that you also handled the Ford Firestone tire situation, which was all over the news, all across the country. So a lot of experience there. When your firm finds a defect in a vehicle, who can legally be held responsible?
Under Florida law, legally, the designers of the vehicle or the product, the suppliers of the product, and the sellers of the product are legally responsible for any unreasonably dangerous and defective product that causes harm to a consumer in the state of Florida.
Now, I would imagine that it's very time-consuming, but how does your firm determine who's actually at fault? Because nowadays it seems like there's so many different companies involved when it comes to putting together a product.
Our firm has access to some of the top-tier experts in the country, most of which are former engineers that work for the vehicle manufacturers themselves. We also have years of experience with our staff and the attorneys, so we know the investigation process and we know what to look for.
Now, you have the experience, you know what to look for, but let's be honest, is it difficult to go after some of these big manufacturers?
It's extremely difficult, especially if you're not prepared.
Right.
You have to have time, you have to have resources, and most importantly, it takes a lot of money to prosecute claims against the major manufacturers like General Motors and Ford and Firestone.
So what should a person do? Let's say someone's watching or they know of someone who thinks that they may have been injured by a defective product. What should that person do?
The first and foremost thing is to preserve the evidence and call an attorney who's experienced in the area of products liability law, and make sure that you get to the scene of the accident, have investigators and paralegals get to the scene of the accident, preserve evidence before evidence becomes missing or just disappears.
Now, when you say preserve evidence, can you be specific about what you mean?
For instance, in a tire tread separation case, there'll be pieces of tread that are vitally important to preserve. So you need to go to the scene of the accident and walk the accident scene for a half a mile up to the point where the vehicle came to rest and gather all the pieces of tread that go with that tire, or to document the skid marks or the gouge marks in the roadway to ensure that the accident reconstructionist expert has all the ample evidence he needs or she needs to give an accurate description to the jury of what happened to cause this accident.
Now, obviously your firm has a big reputation. You've been around a long time. As you said, you've been handling cases like this for years. And it sounds like it would be very expensive and very time-consuming to someone watching to be able to afford to prosecute a case like this involving a defective product.
These cases generally cost six figures in cost alone just to get the case ready for trial.
Right.
It's not uncommon to spend $200,000 or $300,000 to get the case ready to prosecute in front of a jury.
But is there any cost to a person who's watching right now when it comes to talking to an attorney, hiring an attorney? How does that work?
Our law firm fronts the cost,
right,
and then when there's a recovery on the back end, the costs come out of the recovery, but we bear the cost up front. We don't ask our clients to pay for that ongoing cost as the case goes.
Lance, thank you so much. Good to have you here on the
Thank
show.
You.
And that's all the time we have for questions today. And we'll have an attorney from Lytle, Ryder, Smith, Ivy, and Fronrath here every month answering the questions you submit online. So make sure to get those questions in, and thanks for joining us.